We are on a recess roll, so we just need to confirm the number of members with the clerk. All right, we have confirmed we have 12 members present on our recessed roll. That is a quorum. And with that, we will get moving. And I believe I'm going to turn it over to Minority Spokesperson Haas on behalf of Leader Hammond for House Floor Amendment 1 to HB 3392.
You are. Yes, thank you, Madam Chair. I will be presenting that bill on behalf of Leader Hammond. So House Bill, do you want me to go ahead and dive into it?
Yeah, go for it.
Perfect. So House Bill 3392 is actually a gut and replace. The amendment contains agreed upon language that actually brings everyone in agreement. Department of Public Health, DOA, Long-Term Ombudsman, and AARP are all in agreement with this language. It's an initiative of leading age, and basically it's a regulatory cleanup. So what this bill does, sets a pre-admission assessment. It allows it to be completed by a physician, a nurse practitioner, or a physician's assistant. It also allows for issuance of a license to a facility with a full-time director, or the director is allowed to complete their education within 6 months of hire. It adds intramuscular injections as to medication administration, and it also adds a physician assistant who has experience in geriatric dementia care, advanced practice registered nurse who has experience in dementia care for the dementia screening. And if there are any questions, we have Matt Hartman here from Leading Age, who can probably answer them a little better than I can. So, thank you.
Okay. Thank you, Leader Haas. I have just a broad question for you or for Matt. How would you summarize the problem this bill is trying to solve?
I will probably defer that to Matt.
Good morning, Chair. Thank you for the opportunity to deliver what I hope is compelling testimony. Some of this, as Leader Haas, noted, is simply cleanup, but there are a few other pieces. So this helps us to get our assessments done more timely so our residents can be in line, ready to receive the care that our facilities provide. That's the piece dealing with allowing a broader scope of individuals to do the pre-assessments as well as to do the dementia and Alzheimer's assessment. The educational piece for the administrators of our facility just helps us to onboard healthcare employers quicker. It helps us to address kind of just one piece of addressing a broader scope of kind of the staffing shortage that I think all healthcare providers are experiencing still. So it helps us to onboard these folks a little more timely and aligns with what happens in other healthcare settings as well. So nursing homes can do something of this nature. Then the addition of the intramuscular injections to the schedule of medication administration and medication management is just a part of our ongoing effort to allow people to stay in a less restrictive setting for a longer period of time. So this allows something that isn't there already, but allows us to continue down that path of looking at things that can be taken care of in this less restrictive setting, continue to keep them in that setting. And then finally, there is a piece on the repeat violations as well that allows for the department to have some greater ability to take action against providers who are continuing to see some problems, even though some of those are just administrative and technical in nature. So it's a cleanup bill, but it also addresses some small pieces to kind of address the bigger problems that providers have just identified to us over the years as they seek to keep folks in these settings and they seek to just appropriately staff and provide better care.
Thank you, Matt. Sounds like it allows the facilities to be more effective and efficient with their care. Great. Well, I failed to read witness slips, so I'll do that now. We just have one proponent, which is you, on behalf of Leading Age Illinois, so thank you for doing that. And with that, I'm not seeing any other questions. So Rep. Meyer moves to recommend that House Floor Amendment 1 to House Bill 3392 be recommended for adoption. Yes, we do have leave. So with that, there being 12 votes in favor, 0 votes opposed, and 0 voting present, House Floor Amendment 1 to House Bill 3392 is recommended for adoption and will be favorably reported to the House floor. Thank you, Matt. Thank you, Leader Haas. There being no further business, the House Human Services will recess until the call of the chair. Thanks, everybody.
Good morning, everyone. The hour of 9:30 a.m. having come and gone, the House Judiciary Civil Committee shall come to order. Clerk, we are on a recess roll, but I would like to add Representative Didich to the roll. And with that, we just have two things on the order for this morning. That's House Floor Amendment 2 to House Bill 4277 and House Floor Amendment 1 to House Bill 5067. I see that Representative Mayfield is with us. You are recognized to present on House Floor Amendment 2 to House Bill 4277 whenever you're ready, Representative.
Thank you so much, Madam Chair, members of the committee. House Bill Amendment 2 to House Bill 4277 incorporated some of the discussions that we had in this committee when the original bill first came here. Basically, what the amendment does, it clarifies that the 10-year period starts at the end of the sentence, so that somebody who is currently incarcerated cannot apply for a notary. That was one of the suggestions from the minority spokes, and I was happy with that. It didn't change what my intent for the bill at all. So basically, 10 years after release, provided that they have not reoffended, they can apply for a notary license. That's what the bill says.
Thank you, Representative. I appreciate you're taking the feedback from the committee on both sides of the aisle and coming back with an amendment that addressed the questions raised by spokesperson Ugasti in our first hearing. I just want to note for the record on the amendment, not seeing any witness slips. So I just will go to members' questions unless you had someone seeking to be recognized to testify. I have one question from Vice Chair Canty.
Thank you, Chairwoman. Hey, Chair Mayfield, I just had a question because the way I just heard your description, you want to make sure that someone who is currently incarcerated could not become a notary while they're incarcerated.
That was the concern that came up in our original.
Correct, yes, and I fully agree with that. My concern is the way this amendment is drafted, it solves that problem, but then it adds an additional problem by extending their punishment by 10 years from the end of finishing it.
I don't look at that as extending their punishment at all. An individual could have served 5 years. They could have served 10, 20. It depends upon the crime that they committed. That's on them. Right now, they have no recourse at all to become a notary. I am opening the door for them to become a notary. So I know I've heard from some of the ex-offender groups, they felt that 10 years was too long. But like I told them, if you committed a crime that gave you a 20-year sentence, you can't walk out of the door and expect to become a notary. That is not realistic.
I think we'll just have to agree to disagree.
Okay. We can
Thanks.
agree to disagree, but that's where I'm standing. All of the groups that I have spoken to, with the exception of the one that you spoke to, are in agreement with the bill. We need to look at the data for reoffenses. Within those first 5 years is where we see the most reoffending occur. So to give somebody a notary within those first 5 years and then they reoffend and end up back in prison for something else, I just doesn't think serves the purpose of what I'm trying to do. My bill that I have before you today are for those good characters, those individuals who have truly rehabilitated themselves. I believe a 10-year time frame is reasonable to prove rehabilitation, especially considering right now you can't even get a notary.
Thank you, Representative. So, just to kind of recap where we are, currently the law is if you have been convicted of a felony, you're ineligible to become a notary.
That is correct.
So this gives somebody the opportunity to be a notary if they have not reoffended, in other words, not committed another felony in 10 years after the sentence is served. And I want to note also that a misdemeanor is not a bar to becoming a notary, so we're really
Correct.
just talking about felony
There's
convictions.
felony convictions.
Okay. Does anyone else have questions for Representative Mayfield? Spokesperson Freeze.
I appreciate working with you on this and the changes that were made, so we will be up on it. Thanks.
Thank you.
Okay. Do we have additional questions from members? Seeing no further debate, Representative Vella moves to recommend that House Floor Amendment 2 to House Bill 4277 be adopted. Is there leave or partisan? Leave being granted on a vote of 20 in favor, 0 opposed, 0 voting present. House Floor Amendment 2 to House Bill 4277 is recommended for adoption and will be favorably reported to the House floor. Thank you,
Thank you so
Representative.
much.
We're going to stand at ease just for a moment. Okay, we're back on the record. The chair recognizes Representative Katzmull to present House Floor Amendment 1 to House Bill 5067, whenever you're ready.
Thank you, Chair and Spokesperson. We are back on House Bill 5067. As I indicated previously, this bill arose out of a decision from the Illinois First District Appellate Court asking us to take a look at some due process issues surrounding how the IDAS Board of Review functions. The original draft that we received back from LRB had a typo in it that included a very specific salary that was not contemplated as part of the fixed budget that this agency works off of. And so we've backed that detail out of the bill. The conversations with both labor and management have been positive, and so I don't expect any testimony from either today. We continue to talk to the agency about structure, but the model we've adopted here was the one we discussed with the agency all the way back near Thanksgiving that would move us to a 3-member board like other states. So we'd like to take this amendment onto the record and then move forward. I'm open to any questions.
Thank you, Representative. I just want to note there are no witness slips on this amendment. Sounds like a fairly technical one, but I know the underlying bill is really about ensuring that the state of Illinois, the board is in compliance with due process with respect to having a 3-member board. I don't see any opposition. Do we have questions from members? Spokesperson Freeze.
So explain to me again, why are we going from a 5 to a 3-member board?
If you're going to have a multi-member board for review, due process requires that the multiple members all review the files. The agency also works within a fixed budget. This is the same 99+% federally funded budget that every state gets to do this work. Right now, the structure has 5 stipended board members that have sort of an allocation of where they come from. In order to make it feasible to pay both the commissioners and the staff enough to do the work, it makes sense to go down in size a little bit, much like the NCSL data showed us a lot of states have done already.
Okay.
So this is efficiency. This is a mix of how do we do budget and how do we do due process.
Okay, so, and I know they get 15,000 a year, and that there was an amendment that bumped it up to 60, which was not part of your
There was actually an
proposal.
amendment that made them akin to circuit court judges, I believe, which I'm just not sure where that came from. That was never in the pre-draft or anything like that. So that's what we've edited back out.
Okay. All
We're
right,
not
so,
nailing in a particular alternate salary right now for the commissioners.
okay, so whatever they were getting paid before, that's what they're going to get paid now after this legislation or this amendment?
Yes, in the current draft, it would stay as is, and we'd focus on the staff that backed them up, but we're continuing to talk to the agency in case they want to modify the model a little bit more. This would bring us closer to what other states are doing right now.
And how much work do they do? I mean, how busy are they?
It's a good question. So my estimate right now is that there can be as many as 6,000 files, but the review could take as little as a couple of minutes if it's a very simple case, even a really complicated one, 10 to 30 minutes. So the question is how to divide the labor fairly in such a way that we both respect due process and do quality work.
Okay, thanks.
No problem. Thanks for asking.
Representative Fritz is recognized.
Yeah, thank you, Madam Chair. Just one brief question going on this 5 to 3-member board. I understand your reasoning. I guess the question I have is this board of review subject to the Open Meetings Act here in Illinois? Because my concern is if they're supposed to review all the files and they are subject to the Open Meetings Act, if any of them have any questions, they couldn't technically go to another member of the board without violating the Open Meetings Act, correct?
It's a good question. I would want to confirm with the agency. I don't want to answer that question off the top of my head. I will circle back to you.
Okay, appreciate it. Thank you.
Do we have additional questions from members? Seeing no further debate, Representative Didich moves to recommend that House Floor Amendment 1 to House Bill 5067 be adopted. Is there leave or partisan? Leave being granted on a vote of 20 in favor, 0 opposed, 0 voting present. House Floor Amendment 1 to House Bill 5067 is recommended for adoption and will be favorably reported to the House floor. And that concludes our business this morning. With no further business before the House Judiciary Civil Committee, we shall recess to the call of the chair. Thanks, everyone.